Hi, Miss Amanda.
Hi, Miss Asyikin. Hi.
Yeah, have a seat. Have a seat. Thank you. Good morning, Miss Amanda and Miss Asyikin. Thank you for coming in today. My name is Nurin and this is my colleague Syahira. We understand that your company is in the dark times and we are here to help you to explore your financial option.
Morning. Yes, so thank you for meeting with us. Our company, Amanda and Asyikin Manufacturing, is struggling financially and we are not sure what steps to take next. We want to avoid liquidation if possible.
Yes, we are hoping to find a way to save the company or at least handle the situation in the best possible manner.
We appreciate the opportunity to assist you. To get started, could you give us a bit more detail about the current financial situation and any specific concern you have?
Recently, over the past year, our sales have dropped significantly due to increased competition and some supply chain issues. As a result, we have accumulated a substantial amount of debt. We are finding it increasingly difficult to pay our creditors and our cash flows is severely impacted.
In addition to that, there is a lot of pressure from the creditors, some of whom are threatening the election. We have tried negotiating with them, but they are becoming increasingly impatient.
Thank you for sharing that. It sounds like you're having a challenging situation. Have you ever considered any temporary relief option or discussed potential restructuring with any financial advisor?
We have had some discussion, but nothing concrete. We have heard about judicial management and other rescue mechanisms, but unsure how they work or if they are suitable for us.
We can definitely explore those options with you. Before we dive into the specific, Ms. Asyikin, as a shareholder, what are your main concerns and priorities regarding the company futures?
My main concern is preserving any remaining value in the company. I'm worried that if we go straight to liquidation, we will lose everything. I want to explore all possible options to save the company or, if necessary, ensure a fair winding up process.
Understood. To better assess your situation, we'll need some more detailed information. Ms. Amanda, can you provide us with a snapshot of your current financials, specifically your assets, liabilities, and any immediate obligations?
Yes, we have some documents here. So this is our latest financial statement issue.
This will help us get a clearer picture. How about your company's operational aspect? Are there any critical contract or ongoing projects that could be affected by these financial issues?
We have a few significant contracts with key clients, but we are struggling to fulfill them due to cash flow issues. If we can't resolve this soon, we might lose all the clients.
That's crucial information. We'll need to consider these contracts in any restructuring planning. Ms. Asyikin, are there any other stakeholder or key stakeholders we should be aware of who might be impacted by this decision?
Besides Ms. Amanda and myself, there are a few minority shareholders, but they are not involved in a day-to-day operations. However, they will need to inform and possibly consult on major decisions.
Given the circumstances, what would you be preferred outcome, Ms. Amanda?
So ideally, me and Asyikin would like to restructure the company to become solvent again and continue operations. We believe there is still potential in our business if we can get through this tough period.
And you, Ms. Asyikin?
I agree with Ms. Amanda. Restructuring would be ideal, but if that's not feasible, I want to ensure that the winding up process maximizes any recoverable value for all stakeholders.
That makes sense. We aim to find a solution that aligns with your preference. Let's discuss the alternative available for resolving these issues.
Based on what you have told us, your main issues are avoiding liquidation through possible corporate rescue mechanism, and if necessary, conducting a winding up process that safeguards your interests. Does that sound correct?
Excellent. Now let's dive into the alternative. For corporate rescue, one option is judicial management. This involves appointing an independent manager to run the company while attempting to restructure and repay debts. It can provide you with temporary relief from creditors.
That sounds promising. What's involved in applying for judicial management?
We'll need to prepare a detailed application demonstrating that the company is capable of being rehabilitated. The court will then decide whether to grant the order. Meanwhile, an automatic moratorium will be in place to prevent creditors from taking any legal action against both of you.
So specifically, under the Companies Act 2016, Section 405 allows the application for judicial management to be made by the company, its directors or its creditors. If the court is satisfied under Section 406 judicial management orders, which initially have a duration of 6 months, can now be extended for longer periods. It allows approved judicial management orders to remain effective for more than 12 months if needed for the rehabilitation process.
The order is granted as per Section 410. An independent judicial manager is appointed to take the control of the company's affairs, business and property. The moratorium under Section 411 allowing the secure creditors to cover secure movable property during the moratorium period of a company voluntary arrangement, or as known as CVA, or judicial management.
But what if judicial management doesn't work?
Judicial management isn't successful or feasible. The next step would be considering winding up. There are different types of winding up.
For a solvent company, a member's voluntary winding up under Section 432 to 439 can be initiated by a special resolution. This process allows for more control by the company and its shareholders. The section is based on the Companies Act 2012.
For an insolvent company, a creditor's voluntary winding up under Section 440 to 448 might be more appropriate. In this scenario, creditors play a significant role in appointing the liquidator and overseeing the winding up process. Okay.
Voluntary winding up isn't feasible. Compulsory winding up under Section 465 and 467 may be initiated by the court, usually at the request of the creditor. This process involves the court appointing a liquidator to wind up the company's affair and distribute its asset.
In a winding up scenario, we work to ensure that the company assets are maximized and distributed fairly to satisfy outstanding debts as much as possible. This process will involve detailed assessment and fair distribution to ensure all creditors receive their due.
Alright, thank you for the clarification. We will need some time to consider our options.
First, we prepare the necessary documents here and provide you with a detailed explanation of each option. Once you have time to review them, we can schedule a follow-up meeting to discuss your decision and the next step.
We will also provide a briefing documents that outlines the pros and cons of the judicial management versus the different types of winding up. This will include a summary of the relevant section of the Companies Act 2016 and their implication for your company.
Okay, that sounds very helpful. We appreciate your guidance on this matter.
We are here to support you through this challenging period. Let's ensure we take the necessary steps to find the best possible outcome for your company. Okay.
Thank you, Miss Amanda. Thank you, Miss Khairil.
Thank you, Amani.
Let's